So as described in the invitation that you've all received, today's webinar is going to take a look back at some key employment law updates from 2022. And I'm also going to round up today by looking at what we can look out for in this year. So for those that don't know, my name is Laura Spence and I'm a trainee solicitor at Acuity Law and I'm currently sitting in the employment team. So without further ado, I'm going to start with the somewhat confusing topic of holiday pay. So as someone who is trying to really absorb as much as I can from employment law at the moment, I have to say holiday pay is one of the most confusing areas. And we saw a case last year known as HARPUR Trust v BRAZEL, which has made this somewhat more confusing. So in this case, Ms. BRAZEL, a music teacher who was employed on a 0-hour contract to work in a school on a term time basis, brought a claim for holiday pay. Ordinarily, when holiday pay is calculated, we will look to work out 12.7% of the individual's annualized hours. This is on the basis that this is equivalent to 5.6 weeks of the working year. So that's the usual way. But the Supreme Court found in this case that that was not appropriate in the case of 0-hour workers. Instead, we should be looking to calculate holiday pay by looking at the average earnings over the preceding 52 weeks. So this is quite a revolutionary case, and at a minimum, organisations should be reviewing their holiday pay practices at this point to avoid any holiday pay claims. So staying on the topic now of 0-hour workers, in December last year, we saw exclusivity terms for 0-hour workers being rendered unenforceable. Now, for those that haven't seen exclusivity terms in employment contracts before, I have included a couple on the slide here. Essentially, by way of example, imagine you were 20 years old, you're in your first year of university and you would like to earn some extra money. So you manage to get a job with your local restaurant and you sign up to shifts as and when suits you. This may be the occasional Friday, the occasional Saturday, whatever is available. As you get through your year at university, you decide that you want some more money. A couple of days a week isn't great. So what do you do about it? You perhaps approach a local coffee shop and see if you can get some shifts there as well. Under the old rules, if you had an exclusivity term in your contract, you'd be banned from doing this. So this is now unenforceable. And arguably, this is going to provide greater flexibility for a lot of people. Moving on now to the topic of agency workers. We saw a case last year come through the courts which confirmed the regulation 13.1 of the agency workers regulations and how this should be applied. I've included the wording on the screen here. Essentially, the regulation says that an agency worker has the right from day one to be informed by their hirer of any relevant vacant posts within the organisation to give that agency worker the same opportunity as comparable workers to find permanent employment. Now, in this case, the claimant, who was an agency worker, was told that he could not apply for a vacancy that he saw on the notice board. He was told he could only apply for external vacancies along with other external candidates. And he thought this was wrong due to the application of Regulation 13.1. So here, the Employment Tribunal and the Court of Appeal agreed that, unfortunately, he was wrong and Regulation 13.1 should be applied quite narrowly. It is merely the right to be notified of such positions and not the right to be able to apply for them and to be able to be considered for them. This case noticeably brings forward the idea of flexibility in agency worker relationships and provides a useful reminder of this. So moving on now to redundancy and a fair redundancy dismissals in particular. We saw the case of MOGANE versus BRADFORD Teaching Hospital come through the courts last year. And this is a really useful case and provides guidance where there's a selection pool of just one person. By way of brief legal background here, To have a fair redundancy process, the employees at risk of redundancy are entitled to be consulted with at each part of the process. And this may include having the process explained to them, having the selection criteria explained to them, and being able to discuss alternative solutions to dismissal. And by selection criteria, this is quite bluntly put it, a point scoring system to determine the weakest link to be made redundant. So in this case, the employee, who was an NHS worker under a fixed term contract, was told that the trust were facing financial difficulties. Therefore, she was going to be made redundant because her contract was due to expire before her colleagues, meaning that the selection criteria here was solely based on the fact that her contract was due to expire first. And she found this to be unfair, and the courts confirmed that she was right, it was unfair. And we were reminded here that for a fair redundancy process, there must be a genuine and meaningful consultation with the affected employees. This essentially means that the employee should be able to influence the consultation at every part. So in this case, she was given the opportunity to discuss alternative employment, which was unfortunately unsuccessful, but she wasn't given any input on the selection criteria. Therefore, this was unfair. Importantly, this case does not determine that you cannot have a selection pool of one. Indeed, you can. However, it does carry risk, and it is advisable to always have a variety of selection criteria to mitigate this risk. However, should you need to have quite a narrow selection criteria, which may lead to a pool of one person, you must be able to demonstrate that one, there's a rational explanation for having that pool of one, and two, that a reasonable employer would have adopted the pool of one in all the circumstances. Unfortunately, in this case, this did not happen, so it was unfair. It's worth noting at this point that the same rule applies with collective consultation also. Genuine and meaningful consultation is imperative with all redundancy situations. So moving on to my next slide now, which is essentially regarding employees that may be causing a bit of a nuisance within the business. In particular for raising numerous complaints through the grievance procedures. And the case of Hope versus British Medical Association provided some guidance on this and essentially helps us to answer the question, can you fire an employee for raising multiple grievances? Well, this seems a bit harsh, but in this case, it was found that yes, you can. So the claimant here, who was a senior policy advisor, brought a number of frivolous grievances against senior managers, which included matters such as not being invited to meetings. So arguably not something to raise the grievance about. His employer became frustrated at this and warned him not to do this anymore. He didn't like being told this, and in response, he raised another grievance. The employer followed their grievance procedure and invited him to a grievance meeting, which he failed to attend. It was found that his grievances were all frivolous, and ultimately they pursued their threat of treating this as conduct, and he was dismissed for conduct. So the question that arose here was it right to treat the employee's behaviour in raising multiple grievances as a conduct issue? And the court found that yes, it was right to do so. Looking at all the circumstances, the employer had acted reasonably to treat this as conduct, which did warrant a dismissal. However, to do this, a four-stage test should be applied. I have included this on the slides here. Firstly, did the employer hold a reasonable belief that the claimant was guilty of misconduct? Was the belief based on reasonable grounds? Were the reasonable grounds formed on the basis of a fair and reasonable investigation? And finally, did the claimant's dismissal fall within the range of reasonable responses? And the answer to all of these questions was yes, so the employer was right to dismiss him for conduct. It should be noted, this case does not provide a definitive authority that you can always dismiss an employee for raising frivolous grievances. Instead, each grievance should be determined on a case-by-case basis, with the merits of each grievance being assessed. However, it does provide somewhat comfort to employers who may find themselves in this situation. So moving on now to quite a sensitive and very personal topic, and that is in relation to the use of the desired pronouns being used for transgender individuals. And the question here is, was forcing an employee to use those desired pronouns to transgender individuals discriminatory, contrary to their religious beliefs? So the case of MACKERETH told us that no, it was not discriminatory. And in this case, the employee was engaged to assess a number of transgender individuals who were undergoing gender reassignment or were perhaps contemplating this. So quite notably, an important part of his job was to be able to communicate with such individuals and accordingly use the correct pronouns. The employee said that he couldn't do this because it was against his Christian beliefs, and he referenced Genesis from the Bible, and also he did not believe that impersonating the opposite sex could be beneficial to an individual's welfare and that society should not accommodate this. So this indeed went to tribunal because he was later dismissed. Now, the Employment Tribunal never disputed the fact that Christianity was worthy of protection under the Equality Act. But the problem here is that it was the way that this was dealt with in the circumstances. So it was the way that he manifested this belief in refusing to use such pronouns. He brought various claims for discrimination and they all failed. The tribunal reminded us that this is a balancing exercise, and such belief is always subject to protection of rights and freedoms of others in the manner which they chose to manifest those beliefs. And in this case, it was found that the manifesting of those beliefs actually constituted discrimination in itself. Further, his belief that impersonating the opposite sex was not beneficial did not reach the necessary threshold to protection under the Employment Act. Also, it was found that he did not suffer from less favourable treatment. And in any event, if he did, in fact, suffer treatment which his organisation had put into place, which would disadvantage people with the same beliefs as him, this would have indeed been a necessary and proportionate means to achieve a legitimate aim, that being equal opportunity. So it really is a balancing exercise here. And this case joins many others where claimants have been unsuccessful in alleging that they have suffered less favourable treatment amounting to discrimination, because that treatment alleged was due to the way the individual manifested their belief rather than the belief itself. So that is my roundup of 2022. An interesting year for unemployment. I'm now going to move on what we could expect to see in 2023. It is worth noting at this point that this is subject to change and much of the legislation which I'm going to discuss is not in confirmed form yet. So please do bear that in mind. So I'm going to start with retained EU law, and unfortunately we are still finding ourselves discussing Brexit, but this is quite an important piece of legislation. It's something which I've had the time to look at myself a lot, and the impacts that could potentially happen to employment law are quite huge. So essentially, this says that all law derived from the EU must be transferred to UK law, or we will lose them. To put this into perspective, there are currently 2,400 pieces of retained EU law across 300 policy areas and 21 sectors. And the deadline to transfer all of these is the 31st of December 2023, otherwise they will be lost. So this seems quite extreme. Why is it happening? Well, the government say that by ending the special status of EU law, they will reclaim the sovereignty of Parliament and fully realise the opportunities of Brexit. This is fundamentally going to change law as we know it. Laws no longer need to be interpreted in accordance with EU law, and EU law will not take precedence. From an employment law perspective, this covers the likes of working time regs, TUPE, and agency workers. I'm going to focus on working time regs here because I think this is the one which will have many people concerned. So Currently, working time regulations is the reason we have paid annual leave, maximum working days, rest breaks, maximum working weeks. That is all due to the working time regulations. Therefore, if this is not transferred by the 31st of December, we will lose these rights, which is arguably quite a scary thought. So how is this going to work? Who decides what goes, what stays? Government ministers will be deciding. They can decide what goes, what stays, and also they can decide to amend things. And this will be done by a statutory instrument, which is quite concerning because it means the decisions will undergo very little scrutiny. Essentially, changes implemented by statutory instruments are not debated on the House of Commons. Some commentators have said it's inevitable that these fundamental employment laws will be reinstated. However, this is merely speculation and no one knows at this point. Unfortunately, this is going to be a wait and see situation. There is provision in the legislation for this to be delayed another year for complex laws. However, I think perhaps the government may exercise their right to delay as much of this as they can. So perhaps it will be something to look out for in the next couple of years as opposed to now. But again, it is all speculation at this point. It's also worth considering the effect that politics is going to have on this. As I said, government ministers are largely in control of this, and what government party we will have in place by the end of the year is unknown at this point. And depending on who is in power could really affect what happens with employment law. So moving away from Brexit, onto some social and governance issues. So someone did actually ask me a question prior to the webinar about what I think the biggest challenge we could see this year is in terms of employment law. And I personally think that this slide answers that question. The current turbulent economic situation we have found ourselves in with the cost of living crisis and inflation, I think is going to put a lot of pressure on employers. The real living wage was raised by 10.1% last year, and this is the largest increase we've ever seen. For those that may not know, the real living wage is not a mandatory wage. It is recommended and based on the basic cost of living in the UK. So some employers may choose to adopt this, but many do not. I think the pressure of the rise in the cost of living is going to encourage employers to perhaps adopt this where they may not have done before. However, of course, not all employers can afford pay rises. So perhaps there are other things which could be put in place to support their employees. For example, discounts for essential items in stores, options to sell and buy back annual leave, and perhaps a one-off bonus payment to facilitate the cost of living crisis. So moving on to another social issue. In COVID-19 times and with inflation, we have seen a massive rise in pay inequality. And we've certainly seen many debates over the years between gender pay inequality. But last year we saw the topic of ethnic pay reporting come to light. Now, the government confirmed that ethnic pay reporting will not be a mandatory requirement. However, if employers do wish to publish these figures, which they may well do, they will also be required to publish an action plan. And we are awaiting legislation this year to enact this. So staying on the quite dark topic of the cost of living crisis, the next slide is concerning trade unions and industrial action. And indeed, we have seen a rise in both of these in the last year, and this is expected to continue. So we currently have the Trade Unions and Industrial Action Strikes Minimum Service Levels Bill in the pipeline, which the government have said is going to prescribe minimum service levels during strikes. Essentially, this is so no lives are harmed by protecting sectors such as health, transport, education, fire, as listed on the slides here. So the bill will have minimum service levels implemented, and there will be a provision of work notices in the bill. Now, work notices is essentially that the employer must give the union a work notice of at least 7 days before the strike to ensure that minimum service levels are met. If this has failed, then they would potentially lose immunity from tort liability and also protection of unfair dismissal. So it's definitely in the employees and the employer's best interest to ensure this work notice is complied with. There are questions arising about how this will work exactly in practice, and there are proposals to suggest that perhaps agency staff will be able to replace workers in this situation. So I'm sure everyone can appreciate that, you know, trains being cancelled because of strikes and having delays and disruptions is extremely frustrating. So this is a positive step in the right direction of people being able to exercise their rights of industrial action, but still having minimum service levels going so that we can keep moving. Okay, moving on now. This slide is in relation to employee data protection. Now, it doesn't seem like that long ago to me that GDPR came into place and I had thousands of emails in my inbox from every single company I've ever come into contact with regarding the data they stored about me. But the government are now proposing they will be replacing this with a British data protection system, and this should be introduced this year. Details are to follow. The Information Commissioner's Office has also provided they are going to update their guidance, and this is expected to cover the likes of recruitment, selection, employment records, monitoring of workers, and information about health. So this is something to keep an eye on. Okay, I'm next going to talk about flexible working, and I'm sure you'll all agree this has certainly become very normal since we all were told to go home a few years ago and work from home during the pandemic. Flexible working actually technically extends far beyond hybrid working and working from home. It also includes part-time hours, flexi time, and compressed and annualised hours. And the government have confirmed they would like flexible working to be the new default position. And in order for this to be the case, there is a flexible working employment relations flexible working bill in the pipeline currently, which will allow employees a day one right to make a flexible working request. So previously, employees could make such a request, but they had to wait for quite a long duration of time before they could make this request. They could only make one request in a year, and they had to wait 3 months for the employer to come back with the response. They also had to submit quite a lengthy written application as to why they would like to work flexibly and even consider how this may impact the business. So this has been taken away. Employees can now make 2 requests in 1 year. The employer has to come back to them much faster and no written application is required, noticeably making it a much more feasible request for employees to do. This is going to be really beneficial for a range of employees. For example, those who cannot commit to long hours and working every day, who may wish to secure multiple part-time contracts by requesting part-time hours, or perhaps for those high-paid individuals amongst us who have, thrived in their career, but perhaps they now want to start a family and are concerned about plateauing in that respect. They may be able to make a request to support their caring responsibilities. Okay, so moving on now to another quite sensitive topic. We are going to see this year a new duty to prevent sexual harassment in the workplace. And this really does demonstrate a positive response from the UK and something quite forward-thinking. So this is demonstrated by, firstly, the Worker Protection Amendment of Equality Act bill. And this is going to create employers' liability for third-party harassment by putting a duty on employers to take all reasonable steps to prevent sexual harassment of their employees. So currently, the Equality Act will only allow employers to be held vicariously liable where an employee is being harassed by another employee, where they have failed to take reasonable steps to prevent this. But there's no liability in place where that employee is harassed by a third party, for example, a customer, a client, or even a supplier. So they're obliged to take reasonable steps. So what does this mean? Well, this seems like it's going to be positive actions. And to analyse what may be reasonable in the circumstances, it seems that the practicality and cost of such steps may be taken into account. It does seem that the threshold is going to be quite high. Liability will be triggered from the first incident of harassment, whereas previously a sequence of events was required. And the liability on the employer will apply regardless of whether they knew what was going on or not. Essentially, being harassed by a third party will be treated the same as being harassed by a colleague. And the report stage of this and the third reading is expected in February, so more to see on this very soon. And this is complemented on an international level, as the UK has ratified the International Labour Organisation's Violence and Harassment Convention. And this is providing us with a global framework of guidance on sexual harassment. The aim of this convention is to promote that everyone is entitled to be in a workplace free from violence and harassment. And similar to the bill discussed above, only a single occurrence is required. The UK is the 11th country in the world to ratify this convention, and once ratified, we are bound for this for 10 years. So this really demonstrates the positive approach that the UK are taking in terms of sexual harassment in the workplace. Okay, so moving on now to the topic of families, and I've got a few bills on my slide here. The first one being in relation to protection from redundancy for those that are on maternity, adoption, or shared parental leave. Currently, such individuals do have protection during the leave, but not when they return to work. So this bill will provide a total of 18 months protection from redundancy altogether, that being 6 months after the return to work. I think this is a really useful piece of legislation because people that have been on leave may be protected from redundancy during that time. However, when they come back to work, they might not be on top of their game and they thus may be vulnerable. So this 6 months of extra protection really does give a really useful amount of time to be able to get yourself back into work and settled again without that worry. And staying on the topic now of taking away the worry of new parents, there is a neonatal care leave and pay bill in the pipeline, which is aiming to give new parents who have had babies that were sadly born prematurely or very unwell, so have needed to stay in hospital, an extra 12 weeks of leave and pay so they can spend time with their babies during this time and not be worried about returning to work. And finally here, the carers leave bill. This is a really interesting one because there are currently 2 million people in the UK who have care responsibilities, and they're currently having to take other forms of leave to be able to cater for such care. So this bill aims to give carers the right to take up to 1 week of unpaid leave from work. And it is hopeful that eventually this will lead to 2 weeks of paid leave and other benefits. It is said to be a day one right, no qualifying period will be needed, and employees will be protected from any dismissal or detriment as a result of taking this time off. So a really positive move here. Okay, so some final things to look out for. The first one is namely in relation to tipping and service charge. So crucial to the hospitality industry. People have mixed views on tipping, but I think ultimately whether you tip or whether you don't, you would like to think if you are leaving a sum of money, this is going to the staff that have served you and not benefiting the profits of the company as a whole. There is currently nothing in place to ensure that happens. Until now, we have this bill which will ensure that employers pass 100% of their tips to staff with no reductions other than those required by tax law. So really positive step for the hospitality industry. Moving on is in relation to fire and rehire practices, otherwise known as dismissal and re-engagement. And this will occur if an employer wishes to change an employee's terms in their contract, perhaps changing their pay or changing their hours or their responsibilities, and the employee does not agree to this willingly. The way to sometimes get around this is to fire them and rehire on new terms. So following mass redundancies by P&O ferries recently, the government responded to this by announcing it would issue a statutory code of practice to address fire and rehire practices. A very detailed code has now very recently been published, and without going into too much detail now, I would certainly recommend that you have a look at this at your own leisure if you think it is something which is relevant to you. But I will just note a couple of points. It is set to put in place good practices for negotiating or imposing new terms, and failure to comply with these terms may be taken into account in any unfair dismissal claim, resulting in an uplift of an award of up to 25%. It also includes that, should employees dispute this, the employer should examine their business strategy in light of potentially serious consequences for that employee. It also recommends that if further changes are needed, this should be done over a period of time, and further review should happen. And finally here, my final point for today is in relation to the menopause. So the government very recently rejected legislation to offer protection for menopause under the Equality Act. And this was partly rejected on the basis that it may discriminate men in the workplace. And whilst this did not obtain legal protection, it certainly has got people thinking and people talking about this topic, which is really positive to see. So businesses may decide to take this opportunity to consider how they can best support their employees with a view to getting the best out of them, because it is indeed an issue which needs to be addressed for many. And that is the end of my webinar today. Thank you very much everyone for joining. I really do hope that you found it informative. My email address is on the screen. If you have any questions at all or you require advice in relation to anything, please do feel free to get in touch with me. Okay, thank you very much and enjoy the rest of your afternoon.